All right.
Judge, that motion was simply heard by Judge Donovan.
Mhm.
And of course, that hearing was canceled when it got indicted.
Okay.
So we'd like to go ahead and get that heard.
All right.
And then we're here for our first appearance for that meeting. So we do.
All right. Can I get a discovery date on Garza, please? 30. All right. Have you conferred with the state on the GPS conditions?
Just I have not, and we confirm the case filing conditions.
All
Like,
right.
I do not believe that they would be in agreement with any modification on that.
State,
Yes, Judge.
on this case, they're asking that the full GPS conditions be removed.
He stated in opposition.
All right, the court is calling 2025 CR 007531, State versus Jesse Garza. Can I have parties announced?
Justin Pitlock for the state of Texas, Your Honor.
Louis Martinez on behalf of Mr. Garza.
All right, and you are Mr. Garza?
Yes, Your Honor.
And defense, you have a motion to modify release of conditions. You're asking for removal of the GPS?
I'm asking for removal, Judge. I mean, obviously, in alternative, we've got some other options, but at this point, given the length of the time he's been on, the fact that he's had no violations,
All right, how long has he been on GPS?
January 16th. It's January 16th, Your Honor.
All right, and has that been full GPS?
It has been full GPS, Judge.
All right, state they're asking for removal and you're opposed?
We are, Judge. We would say the nature of the offense. You're glad to hear there's been violations since that time, and we would expect on continued GPS that there would still be no violations, but we believe that the nature of the offense, it's an appropriate condition at this time.
All right.
Judge, Mr. Garza works, essentially is a gig worker.
What is a gig worker?
So Judge, he does.
Oh, gigs for shows?
Yes.
Okay.
So he works, he has done some delivery. He has done, it's a stage system. Audio, video work, and so there's no 9 to 5. So the idea of putting him, we'd ask for some relief on that because he's been on GPS for over 6 months at this point.
All right.
He's not been able to work. His mom has been helping him. I don't think that the court wants that situation to continue when he's able-bodied. But what I asked for the court to do is either remove GPS or put him on partial with restricted areas at birth. Because there are times where he's going to get opportunities to work, and that's not going to be a 9 to 5. He's not set up for that. But if we keep him away from the HEB, that's the scene of the incident. We keep him away from other HEBs. If we have him home from certain hours, I don't believe that we'll have any issues with him because we haven't had any so far.
All right, state, any objections to altering and amending partial GPS for employment with a 24-hour notice of work?
No objection to those conditions, Your Honor.
All right, so what the court will do, the court will alter and amend conditions to partial GPS for employment with 24-hour notice. All right, is there anything else?
No, Your Honor, not some.
All right, thank you. ER 007531, State versus Jesse Emmanuel Garza. Can I have parties announced?
Lauren Espinoza for the state.
Louis Martinez on behalf of Mr. Garza.
And are you Mr. Garza?
Yes.
Mr. Garza, did you review the court admonishments with your attorney? Did you understand it, sign it in all the appropriate places?
One.
This document,
Yes,
did you
Your
review that with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes, Your Honor.
You're charged with terroristic threat. Let me see. Threatening to blow up HEB as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
Yes, Your Honor.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is asking that your punishment be assessed at a $1,000 fine, and they're recommending deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 150 hours community service restitution, no contact with HEB on 108 North
Rocio.
Rocio or Sufferino Lopez, Diana Lucera, Mental Health Evaluation and Stress Education Program. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State offers State's Exhibit 1 in all attachments.
That's without objection.
Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Judge, we are. There's just one matter I need to speak to.
Yes.
Judge, given after reviewing the facts with the complainants, given the quality of the case, the state and the defense were able to arrive on this as what we felt was an acceptable resolution for all parties. My client has been on bond on GPS without incident for almost a year. For a very long time, he was on full house arrest and wasn't able to earn a living. He's just now in a position where he's getting back on his feet. The state has no objection to me addressing the fine. I'm asking the court to consider probating all or part of the fine. And I look forward to my client continuing to perform in supervision the way he has in the last year.
All right, so what were your issues? Why did you do this?
So
Judge, if I might speak to that. There, obviously, we all agree that no threats were made in person.
Mhm.
There were some allegations that threats were made over the phone.
Mhm.
At some point, obviously, the state took this very seriously. Initially, we were talking about jail time. At some point, after looking at the case, we agreed that a deferred was more appropriate or in keeping with what happened in this case. My client contends this was a big misunderstanding. His appearance when he showed up the next day caused concern.
What was the misunderstanding?
so I hope I was basically so Your Honor, like what I was in full rest. The company has to post signage, proper signage to
So Mr. Garst was open carrying. He did not believe that the signage at the store complied with what's required by the law. So he did not believe that he was in violation to open carry at the time. Given his conversations with his dissatisfaction with some issues at the store product he received,
So
he shows up open carrying. Everything kind of went bad from there.
all right. So according to what I've read in the STIPs, and everybody correct me if there's anything wrong in the STIPs, it says that he's upset over some propane tanks.
there was a dissatisfaction with a product.
And instead of just going there and saying, hey, your policy is gift cards, I'm not getting a new propane or something else, you're not getting the money back. All you have to do was accept that. And then if you want to go sue somebody for not giving you money back, then that's what you do. But you don't call on the phone and then show up with body armor.
I did he
I mean, that's what it says in the STIP.
And the idea that him showing up in that obviously caused a great deal of concern.
Mhm.
The police were called out. He was arrested without incident. He made bond and he's been supervised without incident ever since.
Do you have any children?
No, Your Honor.
All right, probation. This is what the court is going to do. It's $1,000 fine. It'd be probated, 6 years deferred adjudication, continued GPS partial for employment only, no employment as a home health care provider or with minors, no possession of body armor. I already know there's no possession of weapons as well, but I want you to understand me clearly. That's why I'm saying no possession of body armor, no possession of weapons. Do you understand?
Yes, Your Honor.
150 hours community service restitution. I ordered the stress education course. Once he's completed that, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice. Y'all do a referral to Veterans Treatment Court. There's to be no contact with HEB. You're gonna have to go somewhere else other than a HEB.
And he's been going somewhere else. I think HEB doesn't want him there either. So
And there's to be no contact with the following persons: Seferino, Lopez, Diane Lucera. And there's to be a mental health evaluation. And a TAP evaluation. Out of custody, follow all recommendations. Regular reporting by Zoom or in person, regular random UAs.
Yep.
And there's to be proof of employment within 45 days.
And Judge, he does work, kind of does freelance work, and he's been doing that consistently. The court adjusted his probation, I'm sorry, his bond conditions to allow him to do that.
Yes.
You know, he's been complying with the court's orders and that. So we'd ask that if the court's gonna keep on GPS, and be in keeping with what the adjustments were made on the bond conditions.
Oh, yes, he's allowed to work.
Yeah.
All right.
But the hours are a little out of the ordinary, and they're not.
Oh, just like
Consistent,
probation, no.
And given that he's been on bond since January on GPS, at what point can we reapproach the court to reconsider or to ask for modifications to get on that?
After the holidays.
Easy enough.
All right. Is there anything else that you need from the court?
No, you're
All right. Thank you.
Thank you, Judge.